Imagine being a high-end florist that created a stunning floral arbor for a wedding. The professional photographer at the event took photos of your work and every other vendor's work, which is now prominently featured in their marketing images. Your elaborate floral design likely significantly contributes to the photographer's enhanced portfolio, which ultimately attracts more high-end clients to them and increases their profits, right? But what rights do you have as the florist over your creation once it's photographed and used for marketing? Legally speaking, is there any copyright ownership of that creative work? Or better put, do you have any intellectual property rights of what's within the photos? If you're new to my YouTube channel, my name is Paige Griffith. I'm the CEO and lead attorney behind The Legal Page. We are an online legal education platform for small business owners and a contract shop. We help you get legally legit in no time without breaking into hives. I first want you to understand copyright protection in the context of event design. Copyright law under the Copyright Act of 1976, which is found in Title 17 of the United States Code, is designed to protect fixed mediums of creative authorship. For a work to be eligible for copyright protection, this means that it must be original and it has to be fixed in a tangible form. So it can't be more than like a fleeting moment or idea. Remember here, ideas are not copyrightable. Let's go through the originality and fixation requirements a bit more. What is originality? This means that the copyrighted work must display a minimal amount of creativity and be independently created by the author. So it must be original and creative. So even if a vendor believes that their design is original, it also has to pass what's called a complexity analysis for your work to be eligible for copyright protection. This means that the event designer of a construction must contain a sufficient level of creative authorship. So routine, simple, functional designs might not qualify for copyright protection, and these are the creative works that you probably are making at an event. But even if your work is deemed original, it must also satisfy what's called the fixation requirement under copyright law. Remember here that in order to have a valid copyright, the idea must be fixed in some sort of tangible medium. The primary challenge with event art is that they're short-lived and temporary works. So the pieces that you create as a vendor are often improvisational, constantly evolving, transient, and lots of times they're perishable or decay over time, which means that they don't meet copyright law's requirement for being fixed in a tangible medium. Unfortunately, this means that event designs oftentimes fall short under this fixability requirement. So while floral arrangements and tablescapes and balloon arches and other event decor are undeniably creative and valuable, they are typically considered temporary installations. Alas, once the event ends, the tangible expression of these designs is dismantled, making them difficult to classify as fixed works, which would be eligible for copyright protection. Thus, while many event designs do meet the originality criteria due to their unique and creative natures, they oftentimes fall short again under fixability. So a floral arbor, no matter how intricate, is really just not likely fixed in a medium that can be preserved and is often considered a temporary artistic expression. But certain aspects of event decor that are more enduring, like unique patterns on signage or stationery, could potentially be copyrighted due to their fixed nature, higher complexity, and they won't be dismantled over time. But again, this copyright protection is not automatic, and the event designer would need to file for copyright protection with the U.S. Copyright Office in order to determine if that work was even copyrightable and registrable, or then go to court if the U.S. Copyright Office did not issue you a registration to see if the court would deem it original and fixed enough to be eligible for copyright protection. But that's a lot of work, and I'm sure a lot of you vendors aren't going to do that. So it honestly kind of feels like you're out of luck. But let's get into the issue of the photos that the professional photographers take at weddings and events of your creative works. When a photographer captures an image of an event design, they actually automatically own the copyright to that image. It is well known under copyright law that photographs and digital images garner immediate protection by the photographer who fixes that work in a tangible medium. So when the composition is transferred from the lens and then the shutter's clicked and then it's transferred onto memory card or film, that work receives copyright protection to the photographer who took the photo. Not to mention that the work then becomes more original and more fixed through post-processing and editing via the photographer's style. But is there any legal issue with that potential intellectual property of your vendored work within the images, such as the floral arbor or other design? This is the copyright within a copyright argument for vendors. I know that they're certainly creative and valuable, but as we already explored, that doesn't make the works copyrightable under the law. And I get it. As an event vendor, it really seems unfair that your artistic creations aren't copyrighted under copyright law, while photographers can then license images of your work to third parties, earn money from publications, and then use these images to attract new business to their photography business. So given the limitations of copyright law in protecting temporary event designs, what can you do as a vendor to safeguard your creative contributions? First, contracts and agreements. Clearly outline the usage rights in your contracts with photographers if you have them, and certainly with your clients. So I want you to specify how your designs can be used in certain marketing materials, and always, always, always insist on proper attribution. Although copyright ownership may not be available for your work, proper credit on every image featuring your work really enhances your visibility and reputation in the industry. Next, trademarking. Consider trademarking and potentially even copywriting unique aspects of the designs you create. So you could do this trademark-wise with like a logo or a specific design style that identifies your brand. For instance, you could try to add a logo to the back of a menu you create for a dinner event, or you may be able to have like a card below your wedding cake indicating that your company created the cake. Obviously, there's probably some limitations to this because clients are purchasing your services for their event and they may not want logos or marks on the final design. So you can just chat with your clients there about that. But ultimately, always, always make sure like more back-end work that you create for them. So your mock-up designs, mood boards, and other similar materials do have your logo prominently displayed. Because ultimately, these materials, fixed in a tangible medium, are copyrighted by you as well. So also include a copyright disclaimer at the bottom of documents like this. And 3, this is a biggie here, vendor communication. I really think this issue in the industry all comes down to poor vendor communication amongst everyone there. Photographers, videographers, and all the vendors. So maintain open communication with everyone, especially those photographers that you're working with as a vendor who has creative works in their images. Please explain to them that your creativity is really important and an integral part of those photographers' images. And it's really in their best interest to credit your work in magazines or online publications featuring their images. I really thought that this was common practice in the wedding and event industry, but it doesn't seem like nowadays it is. So just remember that photographers may need a gentle reminder. And by taking these steps, you absolutely can protect your creative contributions and ensure that your work receives the recognition it deserves, even if it isn't copyrighted by you. So remember, ultimately, the pieces that you are creating at an event as a vendor do have creative value. And it's important to recognize that while not all creative works are legally protected, their value in the marketplace does remain significant. So just because something isn't copyrightable does not diminish its artistic worth or impact on your business's success. And as a creative professional, I want you to have this insight and understand these distinctions and then navigate them effectively to maximize the benefits of your work while still protecting your business's interests as much as possible. If you're a vendor such as a florist, a caterer, a cake baker, a venue, a DJ, and you are at weddings and events and you book with your clients and you're looking for more comprehensive protective contracts, I have linked below thelegalpage.com where we have all of those full-length contract templates for you. And if you're interested in hearing more from me about your event vendor contracts, specifically my 3 best contract secrets and 4 things that you can do right now to have a better client contract that will certainly protect your business more than it is right now, head over to my free legal class at contractclass.com. And finally, if you're a photographer who's listened to this video, I wanted to let you know that the Legal Page has a non-exclusive licensing agreement. It's a simple 1-pager legal template that you can use when sharing your images with vendors. So it's crystal clear on what vendors can and cannot do with your images. I will also link that below. Thanks so much for watching. I hope you found some of this information valuable and that it helps you on your vendor journey. If you have any additional questions, I would love to see you in the TLP Facebook community. Until next time, I'll see you in the next video.